welcome to Legally Speaking with me, Tarun Nangia. Today we discuss a very, very important issue. The issue is scheduling of cases to reduce pendency. We will normally be discussing about the Delhi High Court and Supreme Court, but of course, this is applicable to other high courts as well. In the recent times, many good decisions have been taken on this issue, but there are also a few suggestions that are forthcoming. So I have Senior Advocate Percy Bilemoria to discuss this issue with me. He is a senior advocate practicing at the Supreme Court of India, Delhi High Court, as well as is a well-known international arbitrator. Thank you so much for your time and thank you for joining in today.
Thank you, Tarun.
So at the outset, let me ask you that if I give this headline, scheduling of cases to reduce pendency, can I request a few quick comments on this issue at the outset from you?
So, well, look, I think every Chief Justice has his own idea about how to manage the board. I think Justice Lalit was of the view that each bench should be responsible for looking after their own board. I think Justice Chandrachud has brought in quite a few changes. I believe from the AOR group that he is very flexible and open to suggestions and willing to adjust as time goes on. The idea being to manage the caseload more efficiently. Now, there are always different priorities and we all react positively or otherwise depending on what affects only us and our matters. So, for example, the norm for listing of bail cases and transfer petition. Now, it has been reported in the media that this was done because these were the most numerically, statistically, the most number of cases before the Supreme Court. So it would be good to get a few out of the door. Now, this, in my view, misses the wood for the trees because there is a deeper meaning. See, when there is a transfer petition, the underlying matter that is going on in the lower court would inevitably be stayed by the Supreme Court. Not always, but it can be generally expected to be stayed. So if the transfer petition languishes in the Supreme Court, then that means that that entire matter gets delayed. The timeline for that matter gets delayed completely. So it's better to get rid of the transfer petition either which way so that the lower courts can get on with it. So there is a lot of thinking that has gone into this, and it's not ultimately better case management will lead to reducing pendency. Of course, it is not the only solution. I mean, we of course need more judges, which is a completely separate issue. But despite these efforts, which are very good and very positive, resolving pendency is still going to be a long haul and quite a challenge.
I want to know that there have been recently many changes to this issue of scheduling. As you also mentioned in your first answer, that bail petitions are being listed now. All benches are listing transfer petitions, which you mentioned. What are your initial reaction to that? A, and secondly, do you have any suggestions that any more measures that can be introduced, A, at the High Court and B, at the Supreme Court, which would yield to better results? And also some, in a sense, an element of predictability. I don't want to use this. I'm using it in a sense that, many times at 11 p.m., you hear that your matter has been listed for tomorrow. This is what we hear many times when we talk to advocates. Oh, my matter has been listed. Just got to know. 10:30, you're having a dinner with them. They say, no, my matter just come up. So why this happens? And what can be changed so that, there is a certain advance, in a sense, knowledge that your matter is being listed for tomorrow.
So look, if you're asking me, the pendency issue is going to remain. It can only be ameliorated to a certain degree, but it's going to remain. And until, at least at the Supreme Court, there is an allocation of time to each counsel. This is what happens in other jurisdictions. Everyone loves their own voice, and ultimately our system, thank God, I'm saying that it's good that our system is geared towards hearing the party. You must hear the party. So if somebody is making sensible arguments, which are both material and relevant, then the arguments must be heard. But at the same time, the experience, for example, in international arbitrations, we follow what is known as a chess clock system. What that means is, if you've seen a game of chess, there is on one side, there is a stopwatch, and you have only so much time to make a move. And if you exceed that time, then the clock goes, and you lost something in that game. So there is a chess clock system, and in arbitration, there is a very finite, typically 5 days. In those 5 days, the entire trial has to get completed. Now, here, of course, so until we have something similar, this problem of pendency is going to remain for a while. Of course, I'm not suggesting that this be implemented right now, because we are not geared to. Right now, the way we are set up, it is not possible to allocate time. Because, for example, in the US Supreme Court, there are only a few cases that come up. It is possible to have a very good estimate of how much time each counsel would require for that particular issue that is being agitated. Here, there are so many matters of varied jurisdiction, varied laws, and completely different complexity. So you will require a whole new secretariat to read through all the briefs and understand the issues, and then decide on how much time should be adequate and allocate the time. So therefore, we are not geared to it, but that is ultimately the long-term solution. Now, it will also be noted that there have been some very good trends. So, for example, I can tell you that there is now a new trend, which I've also noticed in the Supreme Court, is when you pick up a matter, dispose it off. Right? So typically people say that, okay, well, my board is heavy. There are 50 matters listed before the bench today. So I don't know when my matter will come up. Now, that is not lack of predictability. It is a good system to take up fewer matters, but whatever matters are taken up are heard and disposed of. There is no continuance. Now, predictability comes from a very different issue, which is, I think, you very well touched upon it, Tarun, which is that predictability also depends on the counsel. Now, when there is a matter tomorrow, counsel must be fully prepared for arguments. Right? There was a time not too long ago, before COVID, when if you filed something in the Supreme Court, in the next 2 days, that matter would come up for a hearing. That would be predictability. But now predictability is a little difficult, because you may have, we have got this new system of, tentative date. It will likely to be heard on this tentative date, and then it gets carried forward 2-3 times, and then once it'll definitely come up. Now, it's a different matter if there is already a tentative date, but there are instances, which is what I think you were alluding to. There have been many instances in my own experience as well, where matters which were not even on the tentative list suddenly get listed.
Yes.
And the AOR will get a message or an email, sometimes at 6:37, 8. And then the AOR calls the counsel that your matter listed tomorrow, and you have to send somebody to the chamber to bring the brief home. So I think that predictability, there are other issues as well. Today, there is no, look, the philosophy is that every bench must manage his own board, right? Which nothing wrong with it. But what it also means is that sometimes you find that the order in which matters are taken up is not known till you reach the court. So sometimes you have this ticker tape. There will be an announcement saying all counsels in this matter, please reach court number so-and-so immediately. Right. So Supreme Court has become slightly difficult to manage, I must say. I don't think there's any harm in saying that. And especially for people like me, where you are between either the Supreme Court or the High Court and certain other jurisdictions, arbitrations as well, it becomes a very fine balancing act. But predictability in the system will definitely help counsels manage their own time better. If the counsels are prepared, then it will also help the court to hear and dispose of the matter.
Yeah, because does it help anybody if counsels are hanging around the court all the time, wishing that their matter will just get listed? There'll be time for them to appear. You think that also is a problem, because you have to predict a lot of things, that how much time will it take? Should I just be waiting in the hall? Could you delve into that issue?
Yeah, so it's a little more complex. What happens is that when you are in, let's say, Delhi High Court and Supreme Court, to take a simple example, it becomes sometimes very impossible to predict, right? Because there is a time two courts are very proximate to each other, but it does take a little time. So there have been instances where, I remember on a earlier show, there was a strong opinion in favor of VC hearings. Now, I've seen councils take, VC hearings from the parking lot in the car.
Yes.
I really don't think that was the end and intent behind this provision. VC is meant to facilitate, not to cut short matters like this. So I think predictability is a big issue, and councils at the same time look at. We've been talking for ages about having a separate arbitration bar where there are councils who decide only to do arbitration. That's still a long way off, right? So for somebody who perforce has to do all these different jurisdictions, it becomes difficult to manage the time.
You're right, because I've also seen many times senior advocates being forced to appear from the car in which they are traveling, because maybe they left the Supreme Court and couldn't reach the High Court and the case has come up. They appear from their cars.
Right. It's a talent. I don't claim to have that because I like, as I said in the earlier show also, I like to have face time with the bench.
So I want to ask you that, can there be any changes which makes this more predictable, in a sense that the councils have an idea that when their matter is going to come up, when they need to be in the courtroom at that time? I'm not saying it could be in terms of exact that 2:30 so and so matter will be taken up, so please be present, but at least some approximation. It also reduces a lot of what you can say, people from crowding the court in anticipation that the matter will come up and you'll have to walk in.
Yeah, I think just before I answer that question, the worst thing sometimes is that when you have matters listed, but the matter doesn't reach.
Yes.
Right. And it becomes difficult to also charge the client for that, because that's, really hanging around time.
No, but you spend your whole day in the court waiting for the matter to come up.
See, if you have a matter listed, I mean, you have to be there. You don't know. So we have this terminology called the boat crashed. The boat crash means that you anticipated. So there is a particular talent. There are people who are very, very talented and able to predict that, okay, there are so many supplementaries. Now I'm talking about High Court, okay? So there are so many supplementaries and I am item number so-and-so on the main list. So this will likely reach around 11:30, right? So they will say, sir, please don't come by 11:15. If you come, it's okay. And then sometimes you get a call, frantic call, the boat is crashed. So that's a lack of unpredictability. We've lived with that for many years. And I think it's something that can be easily resolved. It's not that we were not doing that before COVID. I think COVID has come and put a little bit of these things, set them a little haywire. We can certainly go back to the old system.
I want to ask you that outside India, of course, there aren't so many cases. India is a populous country. The litigations are very high. Is there anything to learn from courts outside, or we will have to devise a totally novel system because our caseload and the judge population ratio is also not that good? There are less judges for us. Not many are getting appointed quickly also. So something to delve on that.
So I think the bar has a very major responsibility here, and sometimes as a matter of strategy, people delay hearings. And I'll give you one simple example. So let's take the Supreme Court. Now, if pleadings are not complete, right, there are hearings held by the registrar. It doesn't go before the court. Registrar does not put up the matter before the Supreme Court until pleadings are complete. So it gives an unfair advantage to a party who wants to just drag on a matter. They'll keep asking for time. They'll delay matters. So the party who wants to go to court and get it resolved and get an order is disadvantaged. So there are these kind of situations which need to be handled better. So maybe perhaps, for example, and there are innumerable suggestions here that will come from the bar. So in this case, for example, the registry may put up, a list of non-compliant matters where pleadings have not been completed for a long time on the website. and then list them before the court.
Achha, I want to ask you that in some important matters, each matter is important, but at a crucial juncture there have to be half an hour to 1 hour hearings where arguments will happen. Do you think councils need to be allocated time so that they have an idea that okay, from 3 to 3:30, 3:30 to 4, whatever it is?
Yeah, so that's what I just said, that look, ultimately that is the solution. If there is a matter which is which has a very involved question of law, then in that situation, counsel have to be heard, because ultimately Supreme Court is the last court of last resort, right? So no matter should suffer, there should not be injustice simply because there was not adequate time to be heard. So to allocate time is very difficult. That is the ultimate solution.
Ultimate solution.
But that's not going to happen for a while, because the way we are set up, because there are so many matters of different complexities, there is no way that anybody can read a matter and decide that, okay, this is only going to take 10 minutes or this is going to take half an hour or 2 minutes for that matter.
I want to ask you something from the litigant's point of view, be it a businessman litigant or a common litigant who's doing some personal case. When the matter doesn't come up for hearing, despite being listed, traveling money, hotel stay, other expenses, and you also raise the problem of then the counsels are many times not paid because obviously the case didn't come up. Do you think that it is also that there is an element of harassment here, that for, when the case is not coming up, but you are having to land up anyways and spend the whole day hanging around the courtroom or the hall or the precincts of the court, and then going home empty-handed because you didn't get a hearing?
See, what you're talking about is the Tariq pe Tariq syndrome, right? And that has been an endemic problem. But the good news, Tarun, is that, as I said, there are judges. I know, for example, in Delhi High Court, I can name at least 6-7 judges who will take a matter, hear it till the very end and dispose it off.
Okay.
Right. So now the point is that we have to decide whether what is better. Is it better to have 50 matters listed on the board, which cannot, I mean, look, there is this gentleman called Arun Mohan. I don't know if you've heard about him. He's a senior advocate. I am a great admirer. I think he's quite a maverick and a genius. Now, he's written this book called Justice, Courts and Delays, right? And there he has given an example that of, let's say there are 50 matters on the board, full work gets done in only about 3 to 5, where the matter, sometimes the matter is partly heard and then adjourned in another 5 to 10 cases. In other cases, there is no progress because the counsel is in difficulty or other reasons. So if you look at these reasons, in 6 to 8 cases, adjournment is because something had to be done, but is not done. So I think the bar also carries a little responsibility to do proper case management.
Okay.
Case management, it's not, see, a matter is not just what you argue in court. The matter depends on the preparation and the case management. So if there is a direction which says that next time, please produce a 2-page note, a summary of arguments, and that note is not produced, that's poor case management on the part of the lawyers. So this can be easily redressed. So I think corporate clients are very diligent in that sense, because they have a whole legal department that sees to this, that proper case management happens. But it is really the individual litigants who may not be fully aware of litigation. Many a times, these are the people who are in court for the first time. We have to realize that for lawyers, we litigate every day. So one case is as good as another, but for some people, it is their whole life. It's a very crucial event in someone's case, an elderly person's case, when he has a litigation going on and a lot turns on that for him.
So thanks for all these inputs and sharing your viewpoints today. As we all know that the judiciary is facing a very big problem of, vacancies. Judges have not been appointed. This process has been slow. We hope that many more judges get appointed. Already it seems as per the judge population ratio, we have less judges. But the problem is even those vacancies are not being filled. That is something to worry about even more. We will take up this issue again in a couple of months.
There's one more problem. The problem is that there is luxury litigation where somebody gets into litigation as a strategic issue to defeat competition. This happens in commercial law. So they have a case. It's not that they don't have a case, otherwise they would be thrown out. But the litigation is motivated not by what they hope to achieve, but by the fact that, okay, this is something that I can do in court to stop you with a competitive purpose.
Right. Thanks for that input too. And we also must acknowledge the fact that our judges deliver highest number of judgments come to, as we compare to other courts around the world. Many more judgments are delivered than any other courts, I must say. But I think, yes.
I just want to add that we may be running out of time, but very quickly, there has been this criticism about timing and everything. I think people do not have any idea about how difficult a judge's life can be. Because after court, which is around 5 o'clock, you come home and you have to read the matters for the next day. You have to prepare for the next day. See, the efficiency with which the caseload is managed depends on whether the judge has had the time to read the cases for the next day and whether the counsel have had the time to prepare well for the next day.
Yeah.
It's a tough life.
Point well taken, and we'll take up this issue again in a couple of months. That's it for now. Thank you so much, Senior Advocate Percy Bilimoria, for taking out time and speaking on this important issue. And thank you, viewers, for tuning in. Thank you so very much.
Thank you. Bye-bye.
For more such videos, subscribe to the NewsX YouTube channel, hit the bell icon.